Mr. Atherton, can you hear the court all right? Can you answer that? I'm not hearing you very well.
Yes, sir.
Okay, very good. Very good. Mr. Atherton, you're appearing here today for arraignment on charges of criminal attempt to commit rape, Class A felony, residential burglary, a Class B felony, sexual assault in the second degree, a Class D felony, all charged as an habitual offender. Have you made any arrangements to be represented by an attorney at this point?
No, I have not.
Mr. Atherton, I'd advise you your choices in that area are you have an absolute constitutional right to have an attorney represent you at every phase of this process, and I'm advising you that it would be in your best interest to make arrangements for that. The way you secure an attorney is it's up to you to go out and hire an attorney of your choice. As long as you're hiring the attorney of your choice, the court does not get involved in that. However, if you cannot afford to hire an attorney, then the court does get involved because you're still entitled to an attorney, and the court will make the appointment of an attorney. The appointment will come as a result of you making application on a form that's available there through the jail. You have to fill out that form, turn it in. It'll go to the public defender's office, who will get it in front of a judge to make the appointment. And so if you aren't hiring just a private attorney, then that's what you need to do, is fill out the application and get an attorney appointed in your case. I take it you haven't done that as yet.
No, I have not.
All right. Mr. Atherton, the court is going to, on the charge that I read off, how do you now plead?
Sorry?
How do you now plead? I'm noting a plea of not guilty on the charges. This matter is on the Division III docket of Judge Putman. Judge Putman is here next Thursday, May 25th, and so I'm directing that you'll reappear on May 25th in front. Make sure of that. May 25th in front of Judge Putman. All right. And in the meantime, I'm urging you to get that application, fill it out, and get it en route to the public defender's office so that you'll have it. We have very good public defenders in this area, so you need to get that filled out. All right? You may be excused. Next matter that the court is calling is 2017 206. 2016 393, 2017 134, State of Arkansas versus Tommy Hitt.
Good morning, Your Honor.
Good morning.
I represent Mr. Hitt currently in Division III. I believe that the earlier 2017 case might have already been transferred. At this point in time, we'd ask that both of the cases set in your division be transferred to Division III, where I currently represent him on 16-393, which is the oldest case. At this point in time, Judge, as far as arraignment goes, we would enter a plea of not guilty on these new charges and ask that he be reset in front of Judge Putman next week. I believe there's a order revoking his previous bond, so we'll take that up in front of Division III.
Has 2017-134 has been transferred?
Judge, do you know, Amy, off the top of your head? I'm pretty sure it has been because of the older case, but if it hasn't been, it has. Okay. Perfect. It has
been. The court's
Judge.
directing the transfer of 2017-206 and 2017-134 to the Division III docket. The court will set them all for reappearance Well, now, 2017-206 is for arraignment here today. And on that charge, how does the defendant now plead?
Not guilty, Your Honor.
Has he entered a plea on the two petitions to revoke?
Judge, those are, I believe, petitions to revoke bond
Yeah.
only, so we'll take that up next week.
Will enter a plea of not true in each of those.
Take them up now? No. It's
And all of them will be entered of record as a reappearance for May 25th on all three cases.
Thank you, Your Honor.
All right. Mr. Hitt, you'll be appearing in 1 week from today in front of Judge Putman on all three of these cases. And your attorney has, I guess, will be in touch with you. So you may
Okay,
be.
well, what about a bail reduction?
Andrew.
Your Honor, it's my understanding that an order has been entered revoking Mr. Hitt's bond by Division 3. So at this point in time, there is no bond
All right.
because of the new arrest, and that's what we'll take up next week at a hearing in front of Judge Putman.
All right. That'll be taken up in front of Judge Putman next week. You may be excused at this time. (2016-10) State of Arkansas. That's State of Arkansas versus Jonathan Ybarra. Mr. Ybarra, you're appearing at this time for purposes of changing your plea. Is that correct? On these two sets of charges in both 2016-10 and 2017-22.
Yes, Your Honor.
Okay. And this change of plea in each case is brought about by an agreement that's been worked out for you by your attorney, working out the plea with the prosecuting attorney's office.
Yes, Your Honor.
Is that true also? Yeah. All right. I need you to speak up and answer out loud because
Yes,
the
sir,
court,
it's true.
I can tell what you're doing, but the court reporter has to get your answer on record. That's why I'm asking you to answer verbally, please.
Yes, Your Honor.
All right.
That's true.
Now, the change. Have you gone over with your attorney the terms of the agreement and the punishment you're to receive?
Yes, Your Honor.
And do you feel like you understand what the agreement is?
Yes, Your Honor.
Are you satisfied with the advice and the representation you've received from Mr. Eastman?
Yes, Your Honor.
On the in case 2016-10 on the charge of sexual indecency with a child, Class D felony, and indecent exposure, a Class A misdemeanor. On those two charges, how do you now plead?
No contest.
Is this a no? This is a no contest plea?
It is, Your
Or
Honor.
That's by agreement.
Yes, Your Honor.
I guess I didn't. Yes, you're right. On case 2017-22 on the charge of battery in the second degree, a Class B felony, how do you now plead?
No contest.
On each of these cases, you're pleading no contest in order to accept the agreement we were talking about earlier. That agreement is in writing. There's one plea statement for each case, and the agreement is set out in writing in these plea statements. Have you read over and signed these plea statements?
Yes, Your Honor.
And do you feel you understand what's set out in the plea statement?
Yes, Your Honor.
When you enter a plea, first of all, that mean then you understand the nature of the charges against you and the full range of penalties you're facing?
Yes, Your Honor.
You also set out in the plea statement is the fact that when you enter a plea, you're giving up certain constitutional rights. Do you understand that?
Yes, Your Honor.
When you plead no contest, just like when people plead guilty, you're giving up the right to a jury trial. You're giving up a right to be represented throughout that jury trial and assisted by an attorney who's there to help you prepare and then present your case. You're giving up the right to confront any witnesses that would be called to testify against you. And finally, you're giving up the right to appeal. Do you understand these rights you're giving up?
Yes, Your Honor.
And understanding what rights you're giving up, are you still willing to enter these pleas of no contest?
Yes, Your Honor.
Are you pleading no contest here today freely and voluntarily?
Yes, Your Honor.
Has anybody in any form or fashion forced you into this plea?
No, Your Honor.
Based on the statements made and the presentations made so far, the court will find that the defendant has freely and voluntarily entered his plea of no contest in each case and done so after consulting with his attorney. The court accepts the plea of no contest at this time on the charges that he's entered the plea to, and accepting that plea, the court now calls upon the state to provide the factual basis for the defendant's plea.
Your Honor, in 2016-10, Mr. Yarborough, in 2016, exposed himself to an individual under the age of 15 years of age in a grocery store here located in Mountain Home, Arkansas. Mr. Yarborough did admit to that to law enforcement at the time that this crime was committed, Your Honor. In 2017-22, Mr. Yarborough, at the residence which he resided in, engaged in conduct with an individual in which he committed domestic violence upon that individual and caused physical harm to her. As a result of those charges, Your Honor, and there was injury to this individual. There was also a minor child present. The state brought the charges of battery in the second degree against Mr. Yarborough and the related charges in that case also, Your Honor.
Based upon the acceptance of the plea of no contest together with the statement of facts by the state, the court at this time will, in case 2016-10, find Mr. Yarborough guilty of sexual indecency with a child, a Class D felony, and indecent exposure, a Class A misdemeanor. In case 2017-22, the court accepted the defendant's plea of no contest and heard the state's presentation, finds the defendant guilty of battery in the second degree, a Class B felony. The court is at this time prepared to go forward with sentencing in accordance with the agreement, sentencing the defendant on each felony to 6 years of supervised probation, subject to the standard terms and conditions of probation of this court. On the battery and in 2017-22, that's on the battery, and on the misdemeanor, the court, the misdemeanor in that case was dismissed. The court is sentencing him to 6 years supervised probation, subject to the standard terms and conditions of probation. And notes that the sentence on this case is to run concurrent with the sentence in 2016-10. The court is imposing court costs of $200, a fine of $1,500, a statutory DNA fine $250, and a booking administration fee of $20. All of these obligations are financial obligations are due and payable as a term and condition of his probation, with payments to be made in regular monthly payments at a minimum rate of $100 per month until paid in full. That will be the order of the court in 2017-22. 2016-10, the court has found the defendant guilty of sexual indecency with a child, a Class D felony, and indecent exposure, a Class A misdemeanor. The court will has once again on the felony will impose the 6 years of supervised probation, subject to the standard terms and conditions of probation, and then the indecent exposure, 1 year of probation, misdemeanor probation, subject to the standard terms and conditions of probation. Run those sentences concurrent with each other and concurrent with the sentence already imposed in 2017-22. Court is imposing court costs of $200, a fine of $1,500, a statutory DNA fine of $250, a book administration fee of $20, and the statutory sex offender fee of $250. The court will make that all of those obligations will be imposed on the defendant. The written terms and conditions of probation in each case are attached to the plea statement, or are here with the plea statement. The court is signing those, making it an order of the court that the defendant will be obligated to comply with. The court would note for the defendant that the terms and conditions of probation provide for the probation officer to direct that he be screened for treatment in regard to these crimes, and the court would strongly urge him, given the nature of these crimes, that you take advantage of that. It's you know, you're if you are having what would appear to be substantial problems controlling your behavior, you need to take advantage of the potential treatment that's available under the terms of this plea agreement. You can do it as a condition of your probation, and you should take full advantage of that. If these offenses of this type, of either of these types, occur again, you should fully expect to go to the penitentiary. You're somewhat fortunate not to be going this time. So I understand that the victim was consulted or the victim's family and approved of this, but you should understand that you're very close to going. So if you've got trouble controlling your impulses in these areas, you need to take advantage and address the issue now, rather than because the next time you probably won't have that opportunity to avoid it.
Yes,
So
Your Honor.
that'll be the order of the court. The court's directing that the defendant, the court signed the terms and conditions of probation, and the notes that the defendant himself has signed them, indicating he has read, understands, and will comply with the terms and conditions of probation. I'm directing you meet with the probation officer and get set up on probation.
Your Honor, before Mr. Guevara leaves, the victim in 2017-22 was his wife. His wife, as president of the courtroom, had signed the affidavit requesting us to do nothing in this case. We did not elect to do so, but she is in this courtroom today and has authorized this to take place also, Your Honor.
I understand that. All right, you may be excused to meet with the probation officer. Two 2017-204, State of Arkansas versus Charles Knight. Mr. Knight, can you hear the court all right?
Yes, Your Honor.
All right. You need to move up close to the microphone and speak louder. You're appearing today on charges of possession of a controlled substance, methamphetamine, a Class D felony, possession of drug paraphernalia, a Class D felony, and possession of a controlled substance, marijuana, Class A misdemeanor. On those charges, how do you now plead?
Not guilty.
This case is, the plea of not guilty is noted. The case is assigned to the Division 4 docket of this court. Have you made any arrangements to be represented by an attorney?
At this time, I'm not for sure, Your Honor. I believe, but I'm not positive.
You believe what?
He's not positive.
At this time, I believe so, but I'm not for sure.
Is that because somebody else is making those arrangements on your behalf?
Yes, sir. Parents.
Okay. You find that the arrest date on this is May 11th of 2017, and the court is going to set this matter for hearing in front of, for on this court's scheduling order. The scheduling order will provide for a trial during the week of October 23rd. It'll provide for a pretrial August 17th, and it's going to provide for a reappearance on June 22nd. Those will be the next dates that you'll appear in court. You need to make sure to have an attorney, and because that arrangement hasn't been made yet, June 22nd is the next time I'm going to be holding court. So we'll take that up on June 22nd, but you need to have an attorney far in advance of that date so that this case can start moving forward on the court's docket. All right?
Yes, Your Honor. Can I get a probation lift off so I can bond it out and go back to work? Be able to afford it?
Can you get a what?
I get the probation hold lifted so I can go back to work, bond out and go back to work, be able to afford the attorney?
Well,
I've been through drug court with you. I'm not gonna get in no trouble. I need to be able to afford the attorney if possible. I don't want my parents to have to do it for me. And I have a steady job. I work for myself.
no, we're not putting you on probation at this point.
No, sir. Can I get the probation hold lifted so I may bond out?
Probation's out of Marion County, Your Honor.
Yeah.
Now, it would be appropriate he remain where he is on that at this time.
At this time, that's the ruling of the court, is that the probation hold is out of another county. So in terms of this case, that's where you are. You'll need to make those arrangements. That's something you make through your attorney.
Yes, sir.
Two 2017-208, State of Arkansas versus Jesse Bowman. There's associated with that is a civil case, 2017-164. Charges, you're here for arraignment on charges of possession with the purpose to deliver methamphetamine, Class B felony, possession of controlled substance, marijuana, Class A misdemeanor, 3 counts, possession of controlled substance, Class A misdemeanor, 2 counts, possession of drug paraphernalia, Class D felony, 3 counts, driving on a suspended license, no liability insurance, fictitious license plates, tampering with physical evidence, Class D felony, littering, all charged as a habitual offender with enhanced penalties. On those charges, how do you now plead?
At this time, Your Honor, I plead not guilty. I haven't had a chance to speak with any legal counsel.
Okay? So, what is your plan? Are you hiring an attorney, or are you seeking the assistance of the public defender's office?
I'll probably have a public defender.
Okay. You need to make a written application for that. Those applications are available there at the jail. Get one in your hands and fill it out today. Turn it in so that can start the process. All
Yes,
right?
sir.
You understand?
I do.
All right. This matter is going to be set October 23rd. There'll be a pretrial on August 17th and a reappearance on June 22nd. Get that application filled out as soon as possible, and we'll take up both this and the civil forfeiture case on the 22nd of June. You may be excused at this time.